And I think Adele.
Tom Arras, Main Street South. That must be quite an interesting book you've been reading, Mr. Clark. I thought the goal of the commission was to listen to testimony and pay
I'm
attention
able
to it.
to read and listen at the same time. And I can even see you.
Well, that's very good.
And I can hear you.
I noticed you weren't paying any attention to the
I was
speaker.
paying attention. That's why I wrote notes.
Come on, let's stay within the confines of the
Okay.
public hearing, if you don't mind.
At last month's meeting, I had asked a question where it's established that the commission has the authority to regulate political signs, where is it in the statutes? And acting Chairman Clark replied that they're going by section 8-2, where when I looked at section 8-2, where it goes into amongst the other things that for regulation says, and the height, size, and location of advertising signs and billboards. There's absolutely nothing in there unless you can read something in between those words or in between the lines that pertains to political signs. You had mentioned before about things that have happened around the country. We're not really concerned about what's happening around the country here tonight. What we're concerned about is what's happening here in Connecticut. The Constitution says no law shall ever be passed to curtail or restrain the liberty of speech or of the press. I've been in town since the mid-70s. I've owned my property since 1983. I have had numerous large signs on my property since that time period. The Republicans have had large signs. The Democrats have had large signs. Martin Overton has had large signs. But yet Tom Arras gets taken to task on the Martha Dean sign and the overturned Overton sign and the Mark Greenberg sign. Why is it singled out this way? At the initial hearing or public meeting, October 2010, when I was reading the list of the complainants, which was 13 individuals, you made the comment, something very close to a quote. Why don't you just say the whole Democrat town committee? It was as partisan as can be. We've been bitching for almost 3 years about a partisan issue. Why is it okay? Can anybody in this room tell me why it's okay for others to do it, but not me, to use this type of signage? Why was it okay for you to use large signage, but not me, in the time that this was going on? You did at the Woodbury First headquarters. You had more signage than what I
I put
had.
up signs which exceeded the requirement, and I made them take them down.
Well, they were up there. And they were up there. And it's not okay for one and not for the other. But Dick Crane had them, Charles Bartlett had them, Paul Inkley, George Hale. I mean, this is timeless. It's been going on down there, around town. And this
Can you narrow your comments to the wording of the public hearing, Tom? Because I've heard much of this before. Some
Well,
of it
what's been heard before does not pertain to this public hearing. It has to be repeated in this public hearing to be considered for this public hearing. Am I correct? Or do you just consider everything that's been said in the last 3 years?
What I'm trying to do, Tom, is narrow your comments down to the particular wording, which is the subject. Now, some of what you say about history is relevant. I'm going to ask you to kind of convert.
Okay, it's relevant in the fact that you cannot regulate political signs. Our Constitution states that. It's as clear as can be. And you keep trying to sidetrack us into the U.S. Constitution. This has nothing to do with the U.S. Constitution, what we've been arguing. We've been arguing with the Connecticut Constitution. And, we've had testimony in the past from Martha Dean. She talked about First Amendment and what went on with the U.S. Constitution. And basically, under the U.S. Constitution, you can't regulate tighter than commercial signs. We've had all sorts of people say they want to do it by district. You can't say that constitutional rights vary from district to district to district. That's ludicrous. I mean, it just doesn't make any sense. We also had written testimony that was presented by Deborah Stevenson, and she was talking about the regulations violate the fundamental right of individuals to free speech pursuant to the Connecticut Constitution. The town has no authority under the general statutes to adopt any provision regulating the posting of political signs on private property. And this was last December. She was talking about that regulation at the time as a clear violation of the Article 1, Section 5 of the Connecticut Constitution.
In your opinion, Tom, did she include internally illuminated signs in that statement?
I'll read the whole thing, and you can judge that by yourself. Thanks for asking. No law shall ever be passed to curtail or restrain the liberty of speech or of the press. To the extent that the regulation curtails or restrains the liberty of political speech, the The regulation clearly is unconstitutional, thereby rendering it null and void. It's our belief that the limitations imposed by the regulation impose an unconstitutional curtailment or restraint on the liberty of speech protected by the Constitution. Therefore, we urge the zoning board to repeal the regulation. Keep in mind, this was in December. The Connecticut Supreme Court, from time to time, has reviewed the historical underpinnings of our state constitution and has taken pains to uphold the intent of the framers of that document. The court also has cautioned government officials against infringing on the rights of individuals and the intent of the framers, as exemplified in the quotes below. The Constitution of 1818 not only limited the power of government, but also guaranteed to the people of this state liberty and secured for them fundamental rights. It protected individual liberties against infringement by government. Cologne versus West Farms Associates, 192, Connecticut, 4861, back in 1984. The faith which democratic societies repose in the written document as a shield against the arbitrary exercise of government power would be illusory if those vested with the responsibility for construing and applying disputed provisions were free to stray from the purposes of the originators. If the words have a doubtful meaning or are susceptible to two meanings, they should receive that which will effectuate the intent of the framers of the Constitution and the general intent of the instrument. Because it's evident that your regulation unconstitutionally restricts the fundamental rights of citizens to engage in political free speech, we urge you to repeal that regulation forthwith. If the zoning board needs any reason to repeal the regulation, we urge you to consider that the regulation appears to restrict political speech to a greater extent than commercial speech. The argument alone is sufficient to render your regulation unconstitutional in terms of equal protection, among other things. While it's understandable that the zoning board is attempting to balance all of the political, social, economic, and safety concerns of the town, we urge you to remember that all zoning regulations adopted must be adopted in accordance with constitutional provisions. No zoning regulation of any kind may be adopted if it's not in compliance with constitutional provisions. The town has no statutory authority to regulate political signs on private property. Regulatory and police powers are granted to the town by Connecticut General Statutes 7-148C, 7A. That portion of the statute provides that the town may regulate signs, but only those signs on public property or which affect public property. Specifically, the statute reads, regulatory and police powers, buildings. Make rules relating to the maintenance of safe and sanitary housing. Regulate the mode of using any buildings when such regulations seem expedient for the purpose of providing or promoting the safety, health, morals, and general welfare of the inhabitants of the municipality. Regulate and prohibit the moving of buildings on or through the streets or other public places of the municipality and cause the removal and demolition of unsafe buildings and structures. Regulate and provide for the licensing of park trailers when located off the public highways and trailer parks or mobile manufactured home parks, except as otherwise provided by special act and except where there exists a local zoning commission so empowered. Establish lines beyond which no building, step, stoop, veranda, billboard, advertising sign, or device or other structure or obstruction may be erected. Regulate and prohibit the placing, erecting, or keeping of signs, awnings, or other things upon or over the sidewalks, streets, and other public places of the municipality. Regulate plumbing and house drainage. Prohibit or regulate the construction of dwellings, apartments, boarding houses, hotels, commercial buildings, youth camps, or commercial camps and commercial camping facilities in such a municipality unless the sewerage facilities have been approved by the authorized officials of the municipality. Quite simply, the town has no constitutional authority to regulate the posting of political signs on private property. Therefore, your zoning regulation purporting to do so is in violation of the Constitution and the general statutes such that it must be repealed. We recognize the complexities of the duties of the board, but we also urge you to honor the high responsibility that you have. You are a representative of the people, duly chosen by the people for the purpose of protecting and preserving the rights of the people, most especially for preserving and protecting the fundamental constitutional rights of the people. Within that context, you are empowered to adopt and enforce the law. You are not empowered, however, to adopt or to enforce any law that is not in compliance with the Constitution and that undermines the fundamental rights that the Constitution was designed to protect. For all of these reasons, we respectfully urge you to repeal Regulation 7510 and in adopting any other regulation and to eliminate any further curtailment or restriction on the liberty of political speech within your town. Furthermore, anyone having a direct interest in the subject matter before the Commission has a conflict of interest. You should not be voting on the issue at all, and should recuse himself from the board during the discussion and vote. To do otherwise is wholly improper and affects the legality of any vote taken. This just goes on and on. This is the 35th month of meetings on this subject, and as Mr. Clark was, I think it's kind of pointed out last month, we're on the cusp of 3 years going over this, and it was a 3-month estimate, what you had originally said. And it's far from 3 months, and what's taking longer than 3 months is you keep trying to regulate political signs. It's against our Constitution. That's not going to change unless you change the Constitution. And you're not going through any of the proper steps to even attempt to do that, and it can't be done in this room. And you can't regulate this speech.
Thank you.
You're welcome.
Richard?